We'll follow a team of friends as they leave their tech employers to start a new venture. And then we'll go over some areas of law relevant to startups, mainly corporate and IP. Setup basics, the choice of entity, securing IP ownership, anticipating disputes, how not to get sued by your former employer. Primarily a private employer, although sometimes universities can have claims, even though they're not very litigious. You have to think about that if you're a student. Then IP basics, trade secrets and NDAs, confidential information, trademarks, copyrights, patents. We won't cover VC issues, so liquidation preferences, term sheets, that kind of stuff. It's a whole different topic. Time permitting, we can go back to the team afterwards and see if you have different thoughts about the team story after you learn about the law. So the team has two people, a software engineer and a salesperson in California and an engineer in Texas. Virgil is a software engineer and Vicky is in sales, both at VTech in California. Victor is an engineer for a big defense company in Texas. In September, the three friends agreed to leave their employers next January to start a new venture. And their plan is to seek VC funding and to scale the company quickly. During September through December, they discussed their plans using personal email accounts accessed from their company laptops. In October, they agree via email that they'll be equal partners in the new ventures with generally equal rights and responsibilities. Victor brings up a non-compete clause in his employment contract with big defense company. Virgil once heard a lawyer say that non-competes are unenforceable, and he tells Victor not to worry about that clause. And then in December, Victor transfers code he'd written for a big defense company from his company laptop to his personal laptop. Also in December, Virgil reads that LLCs benefit from favorable tax treatment, and they decide to register Virgil Atlantic LLC with the California Secretary of State. I guess he was a fan of Richard Branson. So this is one slide out of two. Any thoughts so far, anything that catches your eye, good, bad, about what they've done so far? Use of company resources, yes, that's a good point. Anything else you might notice? Okay, one of the employees had a non-compete clause, but they're not worried about it. Okay, good point. Yeah, go ahead. The question is, they will all worked at the same kind of company before. Maybe or maybe not. I don't think it matters for this fact pattern. Right now, two of them work for one company and one for another. It's not really important. The reason I picked this is that some are in California and some are in Texas. They only registered in California, but they don't have a foreign registration in Texas. Yes, good point. All right, so let me go to the second slide. We have more goodies there before we go to the law. So in late December, Virgil prepares paperwork but doesn't get around to filing it. He signs a 3-year lease for office space on behalf of the LLC. The next day, he files registration papers with the California Secretary of State. Then in early January, on his way out to Big Defense, Victor loudly tells everyone what he really thinks about Big Defense Company and its people. Let's just say they're not pleased with that, and he's not pleased with them. On January 3rd, the day after he resigned from VTech, Virgil files a provisional patent application he'd been working on for the past few months. He was very careful to use his own laptop for that. On the same day, he files to register Virgil Atlantic as a trademark for computer software. In early January, Vicky starts calling her contacts at VTech's clients to tell them about her new venture and new product. She calls VCs to set up meetings also and make sure to ask them to sign NDAs. Virgil knows about an open source project on GitHub. Victor asks about GPL, the fact that the project is under GPL terms, and Virgil tells them they can link to the code, to the open source code dynamically, so they don't have to worry about open sourcing their proprietary code. And then in March, the team receives a demand letter from Big Defense Company. Victor is spooked, accepts a tenure track faculty position at Fancy University. He had been talking to them before. And he keeps his ownership share in the LLC. Okay, that's the end of the fact pattern here. Any thoughts on the second slide? Anything that catches your eye here? Vicky's borrowing some customers. That's correct. Yes. That's a problem. Yes. Can't use GPL code even if it's dynamically linked. Yes, that's one of the more. Okay, let's go into the first thing. So let's talk about choice of entity first. Underlying this is a kind of early fork in the road about whether you're going to bootstrap or seek VC funding. And your choice of entity actually will be affected by that. This presentation will focus mainly on companies that will seek VC funding. If you bootstrap, though, you have more choices in this area. So one thing you'd want to generally avoid is to create inadvertently a general partnership. A general partnership is bad because everybody is liable there jointly for what the partnership does, and you generally want to avoid that. And you might create a general partnership even if you don't have an agreement that says, hey, we're creating a general partnership. You can create that by meeting some factors like intent to associate as a partnership in fact. So generally speaking, before you've created the entity, you probably want to be careful so that you're not doing things that might impose liability on you that you haven't thought about. We might go back to the story and talk about if this team did that through what they did. The two major types of entities that you could choose are pass-through entities and C corps. The pass-through entities get taxed once at the level of the owners. So let's say you have $100 in profit at the level of the company, that doesn't get taxed at the level of the company. It gets passed down to the owners or shareholders or members, depending on if you have a corporation or an LLC, and then they pay taxes or they take the losses. A C corp gets taxed twice. So it gets taxed at the level of the company and then at the level of the owners. But you may need to have a C corp if you want to go public and seek VC funding, because a C corp allows you to have lots of shareholders, for example, whereas S corporations and LLCs have limits on the investors you can have. So depending on what you want to do, you may want to choose one structure or another. In our example, they wanted to seek VC funding and scale the company and maybe possibly go public at some point. So for that, a C corp would be the right structure. LLC is probably poorly suited for that. You can change structures after the fact, but it's complicated, and it can have tax consequences. So you'd prefer to avoid that if you can. Most companies that want to scale generally have incorporated in Delaware. That's traditionally the state where people do it because the law is clear. It's set up. The courts are set up to resolve corporate disputes efficiently. However, more recently, Musk had his Tesla compensation taken back, and he said basically he's going to reincorporate in Texas as opposed to Delaware. So this is a very new thing. I don't know if people are going to really start doing this. But let's say 10 years ago, you would have said you have to do it in Delaware. I don't know if that's going to be true in the future as well. Okay, let's talk about securing IP ownership. So generally, a cloud over the ownership of your IP is a problem for investors because they don't want to invest in a lawsuit. They want to invest in your product and your team. If you create uncertainty over the ownership of your IP, either because of claims by your team members personally or because of claims by former employers, that can be a problem for your investors and for you. So first of all, insiders, your own team members. If you don't have any paperwork on this, if you don't have an obligation to assign, by default, the authors of code or the inventors of inventions have rights individually in their in the copyright or patent rights. So there are some doctrines like copyright work for hire and patent shop rights that give some rights to the employer if there's no written assignment obligation, but those are really very limited doctrines, and so you want assignment agreements with your employees, with your contractors. You want to make sure that the startup actually owns the IP rights that it owns. What about claims by your former employer? Somebody mentioned company resources. Yes, don't use employer time and resources. Don't work on a side while you're still employed, generally speaking. It might be okay to work on a completely unrelated field, like let's say you have some hobby and you have an invention there, and you're doing that on your own time with your own computer. You might be able to retain the rights there if you don't use company time and resources. But generally speaking, it's best to wait until you're actually done, until you've left the former employer before you do anything real there. California has a section of the labor code called 2870 that sets up limitations on what employers can ask you to assign. Texas doesn't have a counterpart provision, but some companies in Texas will actually incorporate similar limitations into their employment agreements because, number one, they may have uniform employment agreements across the country, and it's just easier to have everybody have the same one. Number two, they're not interested in these agreements. And I mean, in the IP that it's outside of these areas that are spelled out. So you will often see, for example, UT's IP's policy has very similar carve-outs for things you can do on your own. The thing to remember, though, is if you use company resources or university resources, or if you do it on company time, you may actually not own that IP, or your ownership may be clouded by a claim by the prior employer, and that's something you'd want to avoid. Okay. Number one way to get sued is to just have everybody be mad at you. Like leaving your former employer and telling them publicly that they're all very bad and they're terrible people is a good way for them to start looking for reasons to sue you. So if there's one practical lesson in all this, is that you should leave on good terms. What are some of the claims that a former employer can assert against you? One is trade secret misappropriation. So a trade secret generally is anything that derives economic value from being secret, so anything that's confidential and gives you a competitive advantage. So a very broad definition. Generally speaking, you need to worry about technical information, so things that engineers know, and sales information. So somebody mentioned, Vicky talking to her contacts. That customer list may be a trade secret, and using it at her new employer could very well be a violation and could lead to a claim for misappropriation of trade secrets. You could get sued for breach of the employment agreement. So you can read what your employment agreement says. Non-competes are unenforceable in California. So Virgil was part right, but they're enforceable in Texas as if they are reasonably limited in time and geography and scope. So there you have to go to see what the details of the non-compete are. If it's too long, for example, it might not be enforceable. But reasonable non-competes are enforceable in Texas. So in the fact pattern there, the defense company could actually have sued the team. Less common claims would be copyright infringement if you actually steal code, if you copy code that you don't own. Trademark infringement if you get close to somebody's product or company names, or patent infringement. Patent infringement claims against startups are often, if they're done by a prior employer, they're really because of a trade secret misappropriation claim. They either get piggybacked onto that, or it's a substitute for that because they have a proof problem with a trade secret misappropriation claim. They will generally, it's rare to just get a patent infringement claim for people against a startup that just independently invents something. It's usually because there's a team that left the bigger company that gets hit with that. All right, so basics of protecting now your own IP. For trade secrets, you should take reasonable measures to preserve confidentiality. So that means your employees and contractors should have an obligation of confidentiality. You should restrict access to confidential information if you want to preserve trade secrets, and then mark documents as confidential. Now, if you don't care about trade secrets, you don't have to do all this. But if you want to maintain the protection of the trade secret the trade secret laws, then you need to take reasonable measures to protect confidentiality. One question that comes up is, what if the information, let's say some kind of design information about, so engineering information, what if it's reverse engineerable? What if I got it from my former employer, but I also could have gotten it by reverse engineering the product? Am I then allowed to use it? And the answer is generally no. I mean, you're allowed to reverse engineer it, to actually reverse engineer it if you do it. And that would be okay, unless you have some agreement not to do that. But if you take the blueprints or source code and you use it without permission, right? That can be a trade secret misappropriation, even if you could have reverse engineered it. So that's reverse engineerability is not a defense generally. Actual reverse engineering, though, probably is a good defense. The outer reaches of trade secret doctrine is something called the inevitable disclosure doctrine. So the idea here is, if you go to a company where your role is so close to what you used to do, and you were so exposed to trade secrets at the old company, that you will have to inevitably use your trade secrets at your new job. This doctrine is somewhat disfavored by courts. In generally, it requires that you do something wrongful in addition to just leaving to a position that's very similar. The thing to keep in mind here, though, is that if you do that, if you go to the same position at a competitor, you should keep your nose really clean, because anything you do that's any kind of lying or anything else that you do illegal could be viewed as a threatened appropriation of misappropriation of trade secrets. So if you're in that position, like, everything should be done very cleanly. All right, copyright and copyleft. This is a longer topic, but basically keep in mind there are different licenses out there. You should learn what the license is for the code you're interested in using. The GPL is fairly restrictive. As somebody else mentioned, if the code is under GPL, dynamically linking into it won't save you from having to GPL your own code if you use GPL code. For LGPL, though, which is semi-restrictive, dynamically linking the code might allow you to keep your code proprietary, even if you link dynamically to LGPL code. And other licenses are totally permissive. You can use, like MIT and BSD, you can use your code, you can keep your code proprietary and use open source code in conjunction with it, and you really don't get that many obligations for your own code. When does this come up? It might come up in due diligence, either when you get financing or if you're about to get acquired. There are tools out there, Black Duck and Palamida are some of them. There are more, and they will run your code through those tools, and they'll identify which parts of your code base are open source. So if you knew about it and it's all disclosed, that's great. What can be a problem is if this comes out late in due diligence, people didn't think this was the case. And this has happened. There was a startup a few years ago in Silicon Valley where they discovered that lots of their code was actually open source during due diligence. The deal didn't fall through, but it happened at a much lower price because everybody was surprised. So it's okay to have open source code in your code base, just be aware of it and what it means. Final point, if you are in the AI space, there are right now pending cases on whether training your LLMs, your large language models with copyrighted material is fair use of that material. We'll probably know the answer to that in a year or two. Right now, this is disputed. 2 more slides, one on trademarks and one on patents. So trademarks, something to keep in mind about trademarks is that large companies have an incentive here to go after small fish. In other areas of the law, they don't really necessarily lose their rights by going, by letting things slide. But in trademarks, they can lose their trademark rights if they let you use something that's close to their marks. And they may not want to sue you, but their lawyers may say they have to go after you. And they may do it apologetically. They might send you a nice letter to tell you to stop. But they'll still, generally speaking, you may find that they're pretty protective of their trademarks. Famous marks get additional protection against unrelated goods. So in this case, Virgin Atlantic is a famous mark. You may not want to get close to it, even if the goods are totally unrelated. For small marks, it's not such a big deal. They can coexist. Smaller marks can coexist. I think Delta Airlines and Delta Faucets are both famous. I think what happened there is they predate the dilution statute that happened in the last couple of decades. But normally speaking, big trademarks, like you shouldn't use Pepsi software or whatever, even if you have nothing to do with drinks. Like, stay away from famous marks altogether. When you pick your product and company name, there's a spectrum of distinctiveness. And generally speaking, if you're at the bottom of that chart, I'm not sure you can see it, but at the top you have things like Kodak, Xerox, Google, Apple for computer, or like Blu-ray, SpaceX, Tesla. Those are all okay. The link between your mark and the product is attenuated. It's not very direct. Windows is a terrible name from a trademark perspective. It's descriptive, and Microsoft had big problems actually fairly recently because they chose that name. It ended up being okay for them despite their poor choice, because they were so big and Windows had developed this secondary meaning as meaning Microsoft Windows. So they were able to salvage their trademark, but generally speaking, using a mark that describes very directly your product is pretty risky. Final slides on patents. So why should you patent things? You should patent things if your investors or possible acquirers care about this. It's not always the case. Generally speaking, the more technological the more hardcore your tech is, the more likely you are to want to seek patents. If it's something where you're relying on getting lots of users quickly, patents may not be very important for you. What should you patent? You should try to patent things that are, number one, are valuable, so your customers care. So it's fairly costly and time-consuming to get a patent, so it should be valuable. It should be new, so you can get one. It should be long-lasting, because the patenting process takes a long time. And it should be technological. Business ideas get in trouble in the patent office. So if your idea came out of the marketing department, you may have trouble with that. If the invention is visible, if infringement is detectable, that's a nice bonus. So for example, PageRank, the idea of looking at the strength of the backlinks to decide whether a web page is important or not, that's not really visible. But it's still valuable because everybody uses it, it's long-lasting, the customers care. So it could be a candidate for patenting, and in fact, Google did patent it. If it's actually visible, though, either in communications with users or other computers, then that's an extra bonus. So for example, one-click, Amazon's infamous patent, was visible, and so that was nice from that perspective. It had other problems. It was not really new, so they run into problems for other reasons. But basically, visibility is a nice to have. It's a nice bonus if you have it. When should you patent? As early as you can. Just keep in mind that most rights outside the US are lost immediately upon public disclosure. So if you write something about it, a white paper, or you release your software, you've probably lost rights immediately outside of the US. In the US, you have a limited grace period for your own disclosures. It's about 1 year. The danger there is that you put an idea out and other people do improvements or variations of it, and at that point you might lose your rights. So it's risky to rely on this grace period. It's easiest if you actually try to patent before you disclose yourself. If you have some reason, for example, you think your investors care about having an issued patent, or you have a specific reason to try to get something quickly, there's a way to get a patent quickly within like less than a year by paying an extra fee to the patent office. And with VCs, it's risky to talk to them before you file anything. So sometimes, trying to file something before you talk to VCs is a good idea if you can do that.